Right, I think we can begin. So good morning to everybody. I'd like to welcome you to the first employment law update for 2022. For those of you who don't know me, I'm Graham Damant. I'm going to be facilitating today's session. I'm joined by a team of very talented professionals who will be addressing you, and I will simply introduce them as and when I call on them to speak. For those of you who are not familiar with the Employment Law Update, we have been presenting it for many, many years in different formats. With COVID, we went on to an online format, and we've been presenting this for the last 3 years, or 2 years, I think is how long we've had COVID. Yeah, last 2 years. The purpose of these updates is really to inform people about changes in the law. And surprisingly, after many, many years of having the Labour Relations Act, we still get surprises. The Constitutional Court is interpreting provisions that we previously thought were settled, and we keep getting surprised by new interpretations. So we have to keep you up to date with what's happening regarding that. Also with topical issues. We also try to present cases that are of practical use to you in the workplace. So things that you'll encounter on a day-to-day basis, and to assist you with dealing with those as well. From a housekeeping perspective, all of you are automatically muted and the chat function has been disabled. There is a Q&A function, so those of you who want to have questions during the course, please put them on the Q&A. I'll try and monitor it and direct your question to the correct panelist. I may not get to all of them, but I'll try and select those that I think are topical and we can fit into the question that's being dealt with. We will attempt to be finished by 10:30. We hope 10:30 is a hard stop, but we should be completed well before then. So without further ado, let me then introduce the first panelist, who's Davey. She's a senior director in the employment department, been practicing for many, many years, particularly in the litigious space and particularly in the areas of interdicts. So I've asked Ros to deal with the issue of strikes, because that tends to give rise to lots of litigation and lots of disputes, particularly in our conflict-ridden society. So over to you, Ros, with, I think, the very important Constitutional Court case that has just come out in the last day or so.
Thanks so much, Graham. Good morning, everyone. So yes, the first case that I'm going to be dealing with is a decision by the Constitutional Court that has quite far-reaching implications for employers when dealing with strike interdicts. So this is the case of Commercial Stevedoring Agricultural and Allied Workers Union and others versus Oak Valley Estates, Pty Limited and another. Essentially, what this case is about is an urgent application to interdict strike violence. Now, for those of you who have faced strikes, God, I was going to say in recent years, but I think we've been having strike violence for a lot longer than that. But one of the remedies that you have is to approach the court on an urgent basis to interdict the unlawful conduct. One of the challenges very often that employers face in those circumstances is to identify who the perpetrators of the unlawful conduct is. And so generally, the aim is to look at all the strikers, attach an annexure we call Annexure A with the list of strikers, and seek an interdict against all of those people. What happened in this case is that there was a dispute at Oak Valley Farm, and the dispute was primarily around two issues. First, there were allegations that housing was given to employees on the premises based on race. So there was this dispute that there was racism in the application of housing. And then there was also a dispute because there were a number of employees, the seasonal workers, who were employed by a labor broker, and they were demanding that they be permanently employed and be recognized as permanent employees of the farm. So the dispute went through the motions, it went off to the CCMA, certificate was issued, and a strike notice was then issued. So the strike we're dealing with here is a protected strike. Initially, there were about 364 strikers, but by the time this got to the replying affidavit stage, this had been whittled down to about 174, but still a significant number. Before the strike commenced, the CCMA had determined picketing rules, and the picketing rules provided specifically that there was a designated area for picketing and that strikers could not engage in unlawful conduct, violence, intimidation, damage to property, and the like. Unfortunately, shortly after the strike commenced, the farm experienced significant incidents of intimidation or acts of intimidation. There was damage to property. I think fires were lit, and there was unlawful interference with the employer's business operations. The farm accordingly addressed a letter to the union and copied the union's attorneys and said, please, there are breaches of the picketing rules. There is violence and intimidation. We want an interdict, at least we want an undertaking from you, from the union, that your members will not breach the picketing rules and that your members will not engage in unlawful conduct. The union's response was, you've made vague and general allegations. You haven't told us who is perpetrating the violence and the intimidation, and you haven't told us who's breached, supposedly breaching picketing rules. We can't respond. In any event, we deny that there are any breaches and we deny that there's unlawful conduct. As a consequence of this, the union refused to give the requested undertaking, and the farm approached the Labour Court for an urgent interdict. Now, it was an interim interdict before, so the first step is you go for interim relief because of the short notice, and then seek to get it enforced or made final down the line. So in terms of looking for the interim relief, what the applicant did is they sought an interdict against the union, they sought an interdict against the striking employees, and then they had a category that they called unidentified respondents. And they said that there were unidentified people from the community who were also engaging in this unlawful conduct, and they needed that group of people to be interdicted as well. The Labour Court granted interim relief against all those three respondents or groups of respondents. And the relief granted was that employees couldn't engage in unlawful conduct, they couldn't blockade the premises, they couldn't intimidate other employees or third parties, your general relief that you'll seek in those sorts of circumstances. On the return day, or by the time that it got to the return day, which is the day on which you go back to court to seek to get the interim order made final, the farm had said, we no longer want relief against all 364 employees. Approximately 190 odd employees have returned to work. And so we're only seeking relief against the unidentified respondents, the unions, and this group of 174. The union raised three defenses. They said, firstly, that the Labour Court did not have jurisdiction over a breach of picketing rules. And the reason for that is that Section 69 of the Labour Relations Act provides that if there is a breach of picketing rules, that needs to be referred to the CCMA for conciliation. So they said, you don't have jurisdiction, you never referred a dispute to the CCMA. Secondly, they said that the interdict was unduly broad, and it interfered with the lawful conduct of the strikers. So it had the effect, or it had a chilling effect on the right to strike. It also effectively resulted in an eviction of employees who lived on the premises because they were not allowed onto the premises. So all the employees who lived on the farm had effectively been evicted from their homes. And thirdly, the union said that the employer failed to link the respondents, each individual respondent, to the unlawful conduct that was being committed. So on the return day, the Labour Court accepted that it could not interdict unidentifiable respondents. So it said, I'm not going to interdict people that I can't identify. But it granted the rest of the relief. And the union then approached the Labour Appeal Court. At the Labour Appeal Court, the court looked at the union's three defenses, and it agreed with the union that the Labour Court did not have jurisdiction to deal with the dispute or interdict the picketing rules or amend the picketing rules because there had been no referral of the dispute to the CCMA. The Labour Court also, the Labour Appeal Court also said that the interdict was unduly broad, and it then narrowed the scope of the interdict. But it confirmed the rule insofar as the interdict against violence and intimidation was concerned against all of the respondents. So by the time this matter got to the Constitutional Court, the only issue was whether or not the employer was required to identify each respondent who was responsible for the impugned conduct. And in this regard, the Constitutional Court looked at all the case law as it's developed over the years. And one of the fundamental principles is that if you are seeking final interdictory relief, you need to establish a link between the unlawful conduct that you're seeking to interdict and the persons that you are seeking the order against. So that was a primary consideration, and that was the general principle. And the court said, without establishing that link, you cannot convince a court, or you cannot show that there is a reasonable apprehension of harm that justifies the interdict. And one of the fundamental things that you are required to show if you're seeking an interdict is that you have a reasonable apprehension that harm is going to occur, or you're going to suffer harm as a result of the conduct or anticipated conduct of the respondents. The court also considered the prejudice to employees of being interdicted in circumstances where they might be innocent or they may have done nothing wrong, and was very concerned that a final interdict in these sorts of circumstances would have a chilling effect on the right to strike. And this, the court reasoned, was that a lot of employees may be scared of being interdicted, even if they're doing nothing wrong, because of the conduct of fellow strikers who they've got no control over. And that might result in those employees not going on strike. And the Constitutional Court was also concerned that innocent employees would potentially face a contempt of court application. So ultimately, the Constitutional Court said that they could not establish a link between the 174 strikers and the impugned conduct. And therefore, the Constitutional Court set aside the decision of the Labour Appeal Court in that regard and refused or set aside the final order. What the Constitutional Court said, and what is very important for employers, is that it is essential to identify the perpetrators of the misconduct or the unlawful conduct. So you need to have video footage, you need to have photographs, but it's not sufficient to just put the photographs or the video footage before the court. You need to then identify from the video footage who the perpetrators are. The court did, however, say that in circumstances where you've got a lot of misconduct, there's a lot of violence, a lot of intimidation, it's all being done in a group, then you could possibly interdict the entire group based on the principle of common purpose, to say that group is a cohesive group. They are acting together, they are acting in concert, and therefore they should all be interdicted. But it is important to actually set that out and to justify that claim. The court also said that in the event that you've got a big group of strikers and you have isolated or individual incidents of violence and intimidation, in those circumstances, you can't go against everyone. You need to identify the actual perpetrators. And in this case, the farm had not done so. They had simply put everyone in together. And for that reason, the Constitutional Court said that the interdict could not be made, or that the order could not be made a final order. So this makes it very difficult for employers, especially when you are having, a lot of what we see is that striking employees actually approach the non-striking employees in their homes after hours in the middle of the night. And the violence and intimidation is perpetrated away from prying eyes, let's call it. So it does make it very difficult, but it's very important for all employers facing strike action to have a strike diary, but to go beyond just listing the incidents of unlawful conduct, to taking an active role in identifying those participants. And where it is apparent that actually everyone is acting in concert, it is a general attitude that must be made clear and it must be justified. So the people on the ground who are watching the strike, who are taking the photos, they need to keep a very, very clear and proper record of what is going on, because otherwise we run the risk that when you go to court, the court is going to say, we cannot grant an interdict because you haven't satisfied us that the people against whom you are granting the interdict are actually guilty of the conduct complained of. So a very important case. I think it does make it very onerous on employers when faced with industrial action where there is violence and intimidation. But I think it would be very important in those circumstances to appoint specific people whose job it is to identify and to see who is behaving unlawfully. So in the background, when you approach your attorneys, you've got all that information and you can say, here are the photographs. We've identified the following people. These are the perpetrators. These are the ringleaders. And if you can't identify it, the actual specific people, then you have the evidence to show that all of the strikers are acting in concert, that they're acting with a common purpose to intimidate, to blockade. So a very important case, and yeah, some very important lessons to learn.
Ros, sorry, just
Yes.
one question.
Yeah.
I'm just a bit concerned about the jurisdiction point of saying that the court had no jurisdiction because you had to go to the CCMA. Now, when you're faced with these kinds of actions, you can't go to the CCMA and go through an ordinary 30-day dispute conciliation process and stuff like that. How do you solve that problem by going to court?
So the Act allows you to approach the court on an urgent basis. So you can still approach the court on an urgent basis and say there is a breach of the picketing rules. And I think for interim relief, that should still suffice. But what you need to do at the same time is then refer the dispute, so that in the event that by the time you go back to court, and usually your return day is a month or two down the line, that by the time you've done that, you've still gone through the process, that you've actually followed the mechanisms set out in the Labour Relations Act. So my advice would be seek relief in terms of the picketing rules from the Labour Court on an urgent basis, but simultaneously refer the dispute to the CCMA and take it further, because then the Labour Court, in any event, once you've had conciliation, if I'm not mistaken, the Labour Court then has jurisdiction to determine it as a second phase.
Perfect. And there was a question in terms of people who tried to disassociate themselves by saying, I'm intimidated. But presumably they would have to respond to an affidavit or an urgent application to say, yes, I did it, or I was part of the group, but I was intimidated. They will have to establish that defense.
And yes, sorry, that was an important thing and I missed it. So thank you for bringing me back to that. One of the things that the court said very clearly, that if you've got a group that appear to be acting in concert, so when you've got a lot of violence, a lot of intimidation, the court said that the employees then have a duty to take steps to disassociate themselves from that conduct. And if they don't do so, then there is a very good possibility that the court will be satisfied that they are acting in concert. So they would need to actively disassociate themselves by either putting papers in place or going to the employer or going to their union and saying, please we're not part of this. We know it's happening, but we disassociate ourselves. We are not participating. But the court did say they would have an obligation to do that. Okay. The next case that I'm dealing with is also on industrial action. This is a Labour Appeal Court case. It is Trelicor versus Numza and others. This is a dismissal case where employees were dismissed for participating in an unprotected strike. So Trelicor is a business situated in Durban, and it manufactures burglar guards. I mean, I assume a lot of us have Trelly doors in our house. We know what they are. Now, NUMSA represents members employees of Trelidor. This dispute arose out of dissatisfaction about the job grades of employees. And it goes back to about 2013. It was an ongoing dispute where I think the employees were dissatisfied with their job grades because of their pay. So they believed that they should, their job grades should be raised so they would get higher pay. It was a very, very technical issue. And there were a lot of meetings between the union and the employer. In an attempt to settle the matter, it was eventually agreed between the employer and the union that they would approach the bargaining council, I think it's the Metal and Engineering Industries Bargaining Council, for the council to come in and do a report on the job grades and what grades the employees should be in. But prior to this, there had been threats of unprotected industrial action. And the company had kept on saying, but that will be unprotected. You can't participate and you can't hold us over a barrel. We're taking the steps we need to take. But notwithstanding the employer's attempts to stop the unprotected strike, the employees did down tools. I think it was on about the 25th of June, they downed tools. The employer wrote to the union and to the union's attorneys and said, your members are on an unprotected strike. We will be approaching the Labour Court to interdict the unprotected strike unless they return to work. Please intervene. At the same time, the human resources manager and other members of staff addressed the shop stewards and the workers and informed them that they were on an unprotected strike and they were encouraged to cease with the conduct. They ignored that, and then a verbal ultimatum was issued, whereafter I think 2 written ultimata were issued. Notwithstanding this, the employees refused to go back to work, and the company then said they were going to approach the court. Before they approached the court, the council's representative came into the premises in order to conduct an investigation into the job grading. So he had come in and he was assessing the jobs, he was assessing the grades, he was assessing them against the bargaining council collective agreement in order to determine whether the grades were appropriate or not. At the same time, I think the employees eventually went back to work and the employer decided to take disciplinary action. And it issued written and final written warnings to certain employees depending on their disciplinary record. And it informed other employees that a disciplinary inquiry would be held. So those employees who were already on final written warnings were told that that a disciplinary hearing would be held. Before the disciplinary hearings were held, the council representative came back to the premises to conduct a normal inspection, but also to make sure that he was satisfied that he'd got his report correct on the grading. The employees viewed this with mistrust. They were very concerned and it triggered a lot of anxiety and a lot of problems within the workforce. Subsequent to that, the council issued its grading report, and this was presented to the shop stewards and management. Part of the problem with the report is it identified certain categories of employees where it believed that they were actually graded too high, and it recommended that those job grades be reduced. The shop stewards then said, we're not addressing the employees. You guys, management must address the employees. And management then went and presented and addressed the employees on the report. But one of the things management said is, notwithstanding that the bargaining council has suggested or that the report says we should lower these grades. We are not going to do that. We are not going to reduce anyone's grades, and you will be kept on your current grade, notwithstanding what the report said. The employees weren't happy. They were not happy with the report. They were not happy with the assurances given by the employer. And I think they were still of the view that they wanted an increase in their job grades. They then down to tools again. So the union representatives attempted to encourage the employees to go back to work. They wouldn't, and further meetings were then held. I think then the employer was forced to go to the Labour Court to interdict the unprotected strike. And they got a court order, and they returned to the workforce, and they said to the employees, here is a court order, you're on an unprotected strike, and you have been ordered to return to work. At the same time, the employer said, we are also going to be suspending those employees now who have been involved, or there'll be certain suspensions once again looking at the disciplinary record. That then triggered further industrial action. And following that, the employer took disciplinary action and dismissed employees. And the charges against the employees was that they breached the court order. So they weren't charged for the previous incidences of misconduct. Even those employees who were facing disciplinary action, I don't think they were charged with what happened before the granting of the court order. They were just charged with downing of the tools after the court order had been granted. The difficulty in this case for the employer was that there were two shifts. There was a day shift, there were day shift employees, and there were night shift employees. And once the day shift employees downed tools, the employer took a decision to cancel the night shift because they were worried about violence and intimidation, and they wanted to protect their employees. So they sent out SMSs to say, no one come to work, we've canceled the night shift. Notwithstanding that they canceled the night shift, the company then took disciplinary action against all the employees, both day shift and night shift. They were all charged with breaching the court order, and they were all dismissed for that. The company did not differentiate between the two categories of employees. Now, it would appear that in the disciplinary hearings, the union didn't raise anything about the different shifts. And the employer also did not distinguish between the two groups of employees. They were charged with exactly the same thing. The evidence was exactly the same, and they were all dismissed for the same reason. At the Labour Court, the Quarter Quo distinguished between the night shift and the day shift and said, but wait a minute, how can you fire the night shift employees for the same misconduct as the day shift employees? Because they did not engage in an unprotected strike. They didn't come to work because you cancelled their shifts. And that then became quite an issue, I think, that was dealt with in evidence. The company did not lead evidence to deal with that. The company didn't sort of distinguish or anything. I think there was some evidence in cross-examination, but it was not the primary case of the employer. Now, the fundamental problem there for the employer is, as we are all aware, the onus is on the employer to prove that a dismissal is substantively fair, or for a substantively fair reason. So this was a huge error by the employer, because in failing to distinguish and in failing to highlight what the night shift employees did wrong, they were not able to show substantive fairness in respect of those dismissals. And that's what the Labour Court found. So the Labour Court found that the dismissal of the day shift employees was fair, but the dismissals of the night shift employees was unfair. And the night shift employees were reinstated with retrospective effect. The company then took the matter on appeal to the Labour Appeal Court. Now, there were a whole lot of technical legal arguments about the fact that a lot of the evidence led by the union was new evidence. It wasn't an issue that was raised, and therefore it wasn't something that the employer was required to address. But as I've said, that argument didn't hold water because of the duty on the employer to prove a substantively fair reason. And ultimately, the Labour Appeal Court agreed that the dismissals of the night shift employees was unfair. There was also a cross appeal where the union had sought to appeal the Labour Court's decision that the dismissal of the day shift employees was fair. In that case, the Labour Appeal Court looked at the record and said, these guys have been consistently downing tools. They've received ultimata. They haven't heeded the ultimata. There was a court order. They didn't comply and they downed tools again. And for that reason, their dismissals are fair. So it was a bit of a splitting of the baby there, I think correctly so. But the key lesson for me in this is that it's very, very important for employers, when you are framing your charges, to identify different categories of employees. Now, one of the things that came out in the case was that the real reason for disciplining the night shift employees is when they'd come off night shift, their previous shift, they didn't leave the employer's premises. They supported the industrial action of the day shift employees. So they were, in all likelihood, guilty of misconduct. But that evidence wasn't focused on. That evidence wasn't properly led, wasn't properly pleaded by the employer. And that is what led to a finding that their dismissals were unfair. So please, very, very important, identify different categories of employees and lead the appropriate evidence to prove the appropriate charges against each category, because the charges also should have been different. Any questions on that one?
So there's nothing in the Q&A, Ros, so thank you very much. I know that you've got to leave to go and fight the good fight. So, and I know you love strikes, so good luck. And thank you very much.
Okay, good. Thanks everyone. Thanks, Graham. Bye.
Thanks. Right, the next topic is a retrenchment case that we just want to touch on. It's going to be presented by Melissa Cogger from our Cape Town office. Melissa is a senior associate in the Cape Town office, and she will present to you on this retrenchment case. Over to you. Thanks, Melissa.
Thanks, Graham. So I'm going to be discussing the Kololo versus Grinnell Security Services case. It was a decision handed down at the end of January this year by the Labour Court. And this was a trial that related to a retrenchment. In this case, both parties were not legally represented. So the Labour Court judge actually dealt with it in a similar manner as an arbitration is conducted. And this related to severance pay. So as you know, in a retrenchment process, if an employee unreasonably refuses to accept an offer of alternative employment in order to avoid retrenchment, then the employer is not required to pay the statutory severance pay. That's in terms of the Basic Conditions of Employment Act. And that's 1 week for every completed year of service. And in this case, the employee was a porter at the company's head office, and he worked a 5-day week on 12-hour shifts. And he earned approximately 13,800 Rand per month. He then received a notice inviting him to consult in a retrenchment process, and the company engaged with him on 4 different occasions. And he was offered, as an alternative to retrenchment, a job as a concierge at the company's professional concierge service. It was in a different company within the group, but it was still part of the Grinnell group. And the employee declined to accept that offer, and he was retrenched. And he didn't want to accept that offer because it was with a different legal entity. He was not going to be remunerated at the same rate or under the same conditions of employment that he was currently employed at. And his length of service was going to be interrupted. They were not going to recognize his previous 7 years at the company if he were to be employed by this other entity. So the company retrenched him, and they elected not to pay him severance. and they instead just paid him a gratuity of 5,000 Rand. He then referred an unfair dismissal dispute, and the court here had to consider whether this employee's refusal of the offer of the alternative to retrenchment was reasonable. And the court found in this case that his refusal to accept that offer was actually reasonable. It would have meant a break in 7 years of his employment. The remuneration would have been 4,800 Rand per month with overtime, which was significantly lower than what he was currently earning at the time. And it would have involved shift work instead of Monday to Friday work. So the court found that if the alternative to retrenchment was not reasonable, the employee will not forfeit their statutory right to severance pay. And in this case, the court not only ordered the company to pay the severance pay, it also declared that the dismissal was procedurally unfair in these circumstances and awarded the employee an additional 3 months compensation. It's a nice judgment because it gives us a little bit more insight into what is necessary to consider whether an employee is reasonably refusing to accept an alternative to retrenchment. So it looks at, what are the hours in the new offer of employment? What are the wages? Is there going to be shift work? Is there going to be a break in service? Is it going to be at a completely different location? And it's always going to be a value judgment. There's no, hard and fast rules here. But in this case, certainly if an employee is going to be receiving more than half their salary, it's likely that it wouldn't be unreasonable for that employee to refuse an offer of alternative employment.
Thanks so much, Melissa. Appreciate it. I'm going to then move on to the next case, which deals with private arbitration. And quite a lot of employers do insert private arbitration clauses into contracts, particularly contracts with senior executives, where they'd rather have a matter determined by a private arbitration process, particularly for confidentiality reasons, where you're dealing with senior executives. And what happens if you've got such a clause, and when you do have such a clause, I'm going to hand over to Zawadi Dlamini. Zawadi is a senior associate in our Joburg office. He's my sports law expert, and I will hand over to Zawadi.
Thank you so much, Graham. Morning, everybody. So as Graham said, the next case that I'll essentially be dealing with is the case of Cogger versus Standard Asset Management. It's a decision of the Labour Appeal Court, and it was handed down in December 2021. Now, essentially, this case basically deals with a situation where the parties agreed in terms of employment contract that the matter would be referred for private arbitration. But in the circumstances, the employee referred the matter straight to the Labour Court. Now, the facts of this in a nutshell. So the employee referred an automatic unfair dismissal to the Labour Court. Now, at the Labour Court, the employer argued and raised a point in limine and said that the matter was referred to the Labour Court prematurely, and instead it should have been referred firstly to private arbitration. And the employer relied on the employment contract. But the problem about the employment contract is that it did not expressly provide for private arbitration, but what it actually did is that it referenced the employer's disciplinary policies and its handbook. And those policies referred to a private arbitration process. Now, naturally, the employee argued that the private arbitration clause was improperly incorporated into the employment contract for two reasons. Right? The first reason was that the policies which the employment contract referred to, the employee was not aware of and had not been made available to them. That was their argument. And secondly, the employment contract did not expressly provide for private arbitration. It merely referred to policies that required for the parties to go to private arbitration. And according to the employee, this wasn't properly incorporated into the employment contract. Now, naturally, the question before the Labour Court was there a private arbitration agreement between the parties, right? And if so, could the court stay the proceedings and exercise its discretion and give effect to the private arbitration clause and refer the matter for private arbitration. Now, the court said this: notwithstanding that the employment contract did not expressly provide for a private arbitration clause, it did, however, refer to policies, and these policies were the employer's policies, right? It referred to policies that required for the parties to go for private arbitration. Now, it mattered not that the employee was not aware of these policies, and in fact, it was the responsibility of the employee to acquaint themselves to the policies and know what the policies said. So under these circumstances, the court found that a private arbitration agreement had been properly incorporated into the employment contract. Now, the next step was this. Having found that there was a private arbitration agreement, the court asked, could it exercise its discretion, right, and stay the proceedings in terms of Section 158 of the Labour Relations Act and refer the matter for arbitration, or could it just hear the matter on its own accord? And again, the court highlighted, which is a common principle in our case law, that when exercising its discretion in terms of Section 158 of the Labour Relations Act, the court must exercise its discretion judicially. And it must ask itself whether it's expedient for it to hear the matter as opposed to giving effect to the parties' agreement and referring the matter for private arbitration. And again, what needs to be balanced is two things, right? You have to balance pacta sunt servanda, which is again the intentions of the parties. They've contracted to a certain arrangement. And the second thing that the court must also consider is avoiding a situation where parties abuse Section 158 and circumvent a requirement to go for private arbitration, and they refer a matter which they know should go for arbitration. They refer to the Labour Court in the belief that the Labour Court will hear the matter and not refer it for arbitration. Having considered these principles, the court essentially stayed the proceedings and referred the matter back for arbitration. And again, I think what made it very easy for the court in this situation is the parties did not provide any reasons or any submissions why why it was expedient for the court to hear the matter and not refer it for arbitration. The Labour Appeal Court essentially agreed with the Labour Court and importantly highlighted another very important principle in our case law, which is the fact that when appeal court hears a lower court's decision, and particularly when the decision is one of discretion, a court or an appeal court will not readily interfere with that decision. So what are the takeaways? Right? The two very important takeaways in this case. The first one is this, right? When, as an employer, right, the first prize when you are incorporating a private arbitration clause into employment contract, you want to do it expressly. So you want to avoid a situation where you are referring to policies, right? Because you'll find yourselves in a bit of problems. But even if you do refer to policies, this case demonstrates that those policies will be read together with the employment contract. And if those policies require for private arbitration, it would be read together with the employment contract, and that will be binding on the parties. The second important principle that we can take away from this case, is that courts will most likely give effect to a private arbitration agreement and will not hear the matter themselves, right? So they'll most likely refer the matter for private arbitration where the parties have agreed for the matter to be privately arbitrated. And essentially, that is the conclusion of the case.
Thank you, Zawadi. It was great. Thank you. Right, we're going to move on to...
Interrupt you.
Sorry.
I'm so sorry, Graham, to interrupt you.
Yes, Talita, sorry.
Graham, Zawadi, we often advise clients not to incorporate policies by reference into employment contracts, because if you do that, then changes to those policies need to be effected with the employee's consent, and that is a problem. Whereas if you just state in your contract that the employee is bound by whatever policies are in place from time to time, you could then amend those policies in your discretion and follow a consultation process at most, but not agree the changes. So I just wanted to flag that, that if we are talking about something like restraints and private arbitration, I think it is really advisable to have it in a separate agreement and get the employee's written consent.
Thank you, T. Good point. Zawadi, comment?
Yeah, thanks, Graham. Just 2 seconds. So precisely, it's a very good point, Talita, and that's actually what the court said in this case. Fortunately for the employer, it had that exact provision in the employment contract. So it basically catered for the amendments to the policies, and the employee would be bound to whatever policy was in place at the particular time. So yes, 100%.
Thank you. Right, so we want to now just touch on the case that's been getting quite a lot of publicity in the newspapers. It's a case of Moya and Old Mutual. And I'm going to ask Nikita Reddy, who's a senior associate in our Cape Town office, to talk to us about it. Thanks, Nikita.
Thanks, Graham. Good morning, everyone. So as Graham said, this is a very well-known matter. It's a highly publicized case where Old Mutual suspended and then dismissed the former CEO, Mr. Moyo, due to a breakdown in the relationship of trust and confidence. Now, there have been many different cases in the courts over the last few years, but this one arises from a breach of contract claim brought by Mr. Moyo in the High Court. And he essentially claimed that Old Mutual breached his contract of employment because it wrongfully suspended him without a hearing, because it wrongfully terminated his employment without a hearing, and that Old Mutual breached an implied term of the contract, that it would not victimize him for making protected disclosures. Now, according to Mr. Moyo, all of these breaches entitled him to reinstatement to his position of CEO, or alternatively to damages in the sum of 230 million rand. And now before the trial, Mr. Moyo actually abandoned the claim for reinstatement. So ultimately what was left for the court to determine is whether or not there were these breaches that he alleged and whether he would then be entitled to damages in the amount of 230 million rand. Now, many of you know the facts of this case, but at a very high level, the central issue here that ultimately led to Old Mutual terminating Mr. Moyo's employment was a conflict of interest based on his interest in a company called NMT Capital. And just at a very high level, NMT and Old Mutual had concluded what's called a preference share subscription agreement, in terms of which Old Mutual subscribed for preference shares and would be entitled to redeem them in 5 years. And OM was also entitled to dividends paid by NMT prior to any other shareholders. And it's just important to note that Mr. Moyo held 20% of the ordinary shares of NMT at all material times. Now, in layman's terms, what essentially happened over time is that NMT failed to honor its payment obligations to Old Mutual, but continued to declare dividends, which Mr. Moyo benefited from. And it's also important to note that Mr. Moyo played a key role in declaring those dividends before servicing the pref share dividends payable to Old Mutual, in circumstances when he was also the CEO of Old Mutual, and he actually had a duty to make sure that those agreements were not breached. So you can see how this conflict of interest started to evolve and develop over time. And over time, Mr. Moyo found himself more and more pressed between NMT's interests, in which capacity he received dividends to the tune of about 23 million rand, and his contractual obligations as CEO of Old Mutual. Now, turning to Mr. Moyo's claim, the first alleged breach of the contract related to his suspension, and he claimed that Old Mutual had wrongly suspended him because he had not been afforded a hearing prior to his suspension. And the High Court here said simply on the facts, the suspension was clearly warranted. Mr. Moyo had in fact breached his employment contract, and he benefited in doing so. And the court also noted that Mr. Moyo was aware that Old Mutual had serious concerns with his conduct before he was suspended. So he could have actually addressed those concerns prior to his suspension if he wanted to. And the court ultimately found that suspension in these circumstances was also permissible in terms of Old Mutual's disciplinary code, as it was subject to managerial discretion. So the court accordingly found that his suspension did not constitute a breach of his employment contract, and that claim was dismissed. Now, the second breach is really related to a lot of the previous matters that came before the court, and it was Mr. Moyo's claim that Old Mutual wrongfully terminated his employment contract. And here there was really a dispute about the terms of the employment contract, but essentially the contract actually contained an express clause permitting either party to terminate the employment contract on 6 months' notice. And that was a self-standing clause that was unrelated to the ordinary clause that says that you could be dismissed for any reason in law or contained in the LRA. So this is a self-standing termination clause that allows either party to terminate on 6 months' notice. And this is the clause that Old Mutual invoked, and the court held that there was clearly no breach of contract here because the term is quite clear. Mr. Moyo raised a number of arguments in this regard, and he tried to reference the disciplinary policy, which requires a hearing, but the court found that that was all irrelevant because the particular clause that Old Mutual invoked didn't require any of that, and it allowed Old Mutual to terminate on 6 months' notice. And that's exactly what Old Mutual did. So there was no breach of contract in that regard. And the third breach, or alleged breach, was based on an implied term in the contract that Old Mutual would not victimize Mr. Moyo for making protected disclosures. Now, we all know that employees are generally protected in law from making protected disclosures, and employers are precluded from retaliating in any form. And that was essentially Mr. Moyo's argument here. And his claim was based on certain allegations that Mr. Moyo had made over time in respect of the chairman of the board and the company, which he claimed constituted a protected disclosure. Now, the court went into an analysis here and essentially found that there was firstly no basis for Mr. Moyo to even believe that he had made a disclosure. So it's not even whether or not he should have been protected and whether Old Mutual retaliated by suspending and dismissing him, but actually he didn't even pass the first requirement of establishing that he made a disclosure, because on the facts, there was no impropriety on the part of Old Mutual or the chairman of the board, and so there was no basis for his claim that he made a disclosure that needed to be protected. And similarly, there was also just no evidence that he had been victimized by Old Mutual. And so ultimately, the court held that all of his claims were unwarranted, and the matter was dismissed on that basis. Now, what's an interesting takeaway, I think, for employers here is that the contract had the self-standing termination clause on notice, and it's something that employers might want to consider, particularly in relation to its more senior employees. But what you'd also need to bear in mind is that while that clause would allow you to terminate, presumably on notice, under contract, and there would not be a breach of contract claim, employers just need to bear in mind that an employee would still have the option of bringing a fairness claim under the LRA. So in this case, Mr. Moyo didn't do that. He limited his claims at all material times to high court contractual claims. He chose not to go the CCMA route and claim that he'd been unfairly dismissed. But I think on these facts, Old Mutual would have had strong grounds to defend any kind of fairness claim on the basis that it had a fair reason to dismiss him. And actually, he had multiple opportunities to make representations along the way. But there's just something to bear in mind that if an employer chooses to have this sort of self-standing contractual termination clause, you just need to be mindful when you invoke it that you might be opening yourself up to a claim in the LRA for an unfair dismissal.
Thank you, Nikita. Yeah, and I think, the important issue is that he elected to bring just a contractual claim, and that this issue was determined purely on a contractual basis, not on any other basis. Right. I'm now going to. I've given Talita a short pass on the next matter, which is a constitutional court matter, but it's incredibly complex. And I knew that only Talita could do justice to it. So, as a senior partner and my most academic partner. So I've asked her to touch on it and to deal with that. Thanks, T. Over to you. Sorry about the short pass.
Thank you, Graham. Yeah, no, Graham always uses these opportunities to educate me on sections that I actually have never dealt with before in the LRA. And this one is a demarcation dispute. there were a whole host of respondents in this case, all of whom, well, most of whom are companies in the automotive industry, so they say. And interestingly, they fell under the scope of the Metal and Engineering Industries Bargaining Council. They went to the CCMA and said, actually, we must fall under MIPCO, the Motor Industry Bargaining Council. All our competitors fall under MIPCO, and it is actually correct for us to fall under MIPCO as opposed to the MEIBC. So this was then a dispute under Section 62 of the LRA. And this is very interesting because what Section 62 says one needs to do in these kinds of disputes is you refer the matter to arbitration. The matter is heard as an arbitration, but if the CCMA believes that this matter is of substantial importance, it must actually publish a notice in the Government Gazette and call for written representations from anyone who might be interested in this matter. And then the CCMA may not commence with those arbitration proceedings before it has considered the representations, and secondly, consulted with NEDLAC on the award. So it may not issue an award before it actually told NEDLAC about this matter and what the proposed award is going to be. And then once that award is made, a notice must be sent to the Labour Court and the CCMA. And again, if it is substantially important, the CCMA must then publish a notice of that award in the Government Gazette. So this is a bit of a different process to what we are used to in normal employment disputes. So these two bargaining councils now fought for membership. The MEIBC obviously wanted these companies to fall within their scope, and MIPCO wanted them under their scope, and this matter was before the CCMA. Very interestingly, NUMSA and the MEIBC produced a document of 60 years old. It's a demarcation determination of 1962. And in terms of that determination, these companies fell under the MEIBC. That was the first thing that persuaded the commissioner that they need to stay under the MEIBC. The second thing that he then looked at is how do you determine whether an industry falls within a particular scope of a bargaining council? And he said it doesn't matter what the end product is. That's not the focus. The focus is the manufacturing process. So are we using engineering, all of these things that the MEIBC does, or is it a motor manufacturing type process? And the commissioner said, no, we look at the manufacturing process. We do not have regard to the end product, and therefore they need to stay under the MEIBC. Now the companies said, listen, we manufacture motor vehicle components. Our customers are these motor vehicle companies like Toyota and Mercedes and Volkswagen, and we provide to them. We form part of the value chain in motor vehicle components. We fit within the Motor Industry Bargaining Council. And actually, you need to look at that fact, and you need to look at the end product. So off they went to the Labour Court, and they, first, obviously, the commissioner went to NEDLAC and said, this is the dispute, and this is my proposed award. They engaged with the commissioner. The commissioner provided a revised award. they again engaged and they said, listen, we're not agreeing with you that you can just rely on the 60-year-old determination and the manufacturing process. Actually, that's not the test. But by then, it was 9 months since the arbitration, and NEDLAC then said, okay, fine, just issue the award, and we defer to you now. So part of that is, of course, because the section says you must consult with NEDLAC, doesn't say you must agree with NEDLAC. So that award was issued. The commissioner said, MEIBC, that is where you fit. Off they went to the Labour Court. The Labour Court looked at it and said, no, the commissioner committed a material error of law when it thought that 1962 determination was binding on it. That had only historic relevance for why these companies were under the scope of the MEIBC. The commissioner was required to determine afresh whether this is the correct determination, and that he failed to do because he thought that that determination somehow was binding on it. Secondly, the court said, no, you do not look at the manufacturing process. You actually do look at the products, because when you look at the scope of the definition in both the MEIBC and MIPCO, they refer to products, motor vehicle spares, components, appliances, that kind of wording. It is not the process of manufacturing those. Very interesting also, the MEIBC main agreement has a specific exclusion for motor vehicle components. So it actually acknowledges that it doesn't apply to these kinds of companies. On that basis, the court said, I'm reviewing the decision of the commissioner, and then it replaced that decision with a finding that actually these companies fell under MIPCO. Aggrieved with that decision, NUMSA and the MEIBC took the matter on appeal to the Labour Court. The Labour Court said there was nothing wrong with what the Labour Appeal Court said there was nothing wrong with what the Labour Court did, and off NUMSA and the MEIBC went to the Constitutional Court. The Constitutional Court said, essentially, there are two questions. In the context of Section 62, can the Labour Court review an arbitration award dealing with a demarcation dispute? And secondly, because of this requirement to consult with NEDLAC, can the Labour Court replace that decision of the CCMA Commissioner for another bargaining council without talking to NEDLAC at that point? So first, the court said, yes, the Labour Court's powers to review are dealt with in Section 145 and 158 of the Labour Relations Act. There's nothing in those provisions that prevent the Labour Court from reviewing a demarcation determination award under Section 62. So the court had the power. And secondly, the Labour Court doesn't need to consult with NEDLAC. That procedural step was complied with after the arbitration award was drafted and before it was issued, and it is not necessary for the Labour Court to again consult with NEDLAC, and therefore it was permitted to replace that demarcation decision for MIPCO. The court also agreed that it was wrong that the commissioner relied on the 60-year-old determination, and it also agreed that you actually look at the manufacturing process. No, you look at the products that are being produced. So in the end, that appeal to the Constitutional Court was dismissed, and these companies, together with their competitors, now fall under MIPCO.
Thank you, T. I knew you'd do justice to it. Thank you very much. Now, we're going to move on to more contentious areas, and that's the issue of compulsory vaccinations and the question of incapacity terminations that arise when employees refuse to be vaccinated. And we're going to deal with the first of the CCMA cases, which is the Mulderich versus Gold Rush Group. And over to you, T. I know you're very familiar with all the COVID-related issues that are going on at the moment.
Yeah, thanks, Graham. Perhaps as background, you will be aware that there are a couple of cases already in the courts. There was a case in the Labour Court, Solidarity versus CISA. It was brought on an urgent basis to suspend the application of a mandatory vaccination policy. That matter was struck for lack of urgency. Kuro, we heard earlier in the week, that was a case in the High Court in Cape Town, again struck for lack of urgency. The Kuro judgment, the Rhodes University judgment, the Free State for Choice judgment, they are all in the High Court. Kuro in the Western Cape, Rhodes in Makandla, I think is the area, Free State for Choice in Bloemfontein. All of those matters involve a review of the university's or Kuro's council's decision to implement the policy in terms of which employees or students, in the case of the universities, need to be vaccinated in order to access the premises. And the Free State for Choice matter, also it was struck for lack of urgency, also the Rhodes University one. So these, I think it is because this is such a complex thing that the applicants in this matter needed time to prepare their cases, and it took them very long to do that. And therefore, the courts have no hesitancy in striking them for lack of urgency, but the ultimate review applications will still be heard. We are involved with the University of the Free State matters. The Free State for Choice matter is being heard on the 23rd of March, and that is then the substance of the review. Also, there is a solidarity application against the University of the Free State that we are assisting with, so that is it is keeping us busy, all of these matters. In the meantime, there's been cases in the CCMA, and Theresa Mulderich and Gold Rush Group is the one that we are talking about now. Gold Rush Group conducts business in the hospitality sector, and Theresa was employed as a business-related and training officer. And as such, she interacts with employees on a daily basis. Now, shortly after the direction that makes provision for employers to implement these policies was published on the 11th of June last year, Gold Rush met with its exco. It discussed the various possibilities, the nature of its business, and it decided, that there was basically two options. The one was to have a mandatory requirement, and the other was more of a encourage and recommend route. It discussed its proposal with its lawyers, CDH, and they then established a committee who prepared a mandatory vaccination policy, because that was what the management at that time was thinking is the appropriate way to go. They then consulted with the unions, as they are required to do under the direction, and they had a question and answer session with all of their employees. During that question and answer session, interestingly, they had 3 specialists: a traditional healer, a medical specialist, and lecturer in traditional health, a virologist, and a human rights commissioner from the Human Rights Commission. So they fielded questions from the employees and then they put in place this policy. The main purpose of the policy is to create and maintain a safe working environment for all of the employees. And then they considered Ms. Mulderay. They said the nature of her duties as a training officer, she deals with the employees all the time. And actually, there is no other position where she can be reasonably accommodated. So the commissioner then said, yes, we can see that her duties require interaction with fellow employees. And actually, her failure to get vaccinated is not only in breach of the policy that requires her to be vaccinated, it is actually also a breach of her duty under the Occupational Health and Safety Act to ensure a safe working environment. Nevertheless, doesn't matter that there are these breaches. It was the commissioner agreed that she was now permanently incapacitated to performing her services as training officer. And it then held that her dismissal for incapacity was fair. Now, the question that we grapple with often is, how do you categorize these instances? Is it a misconduct issue or is it an incapacity issue? I think a lot depends on the facts of the particular matter. But in essence, what an employer needs to do in any dismissal situation is to afford the employee a reasonable opportunity to make representations. That is done through a disciplinary inquiry process in the case of misconduct and an incapacity hearing type process in the case of incapacity. But in both circumstances, you are required to listen to the employee's representations, and dismissal needs to be a matter of last resort. So in both instances, you need to see whether there is a way in which you can actually accommodate this employee. In this case, they went the incapacity route, and the CCMA agreed that that was fair. So yeah, we know that there are, I think, about 177 cases before the CCMA, and we are eagerly awaiting the outcome of those matters. And in the meantime, we wait to see what the High Court is going to do with the review applications.
Thanks, T. I mean, obviously a very, very interesting area and one to watch. We're going to see lots of judgments coming out, I imagine, in the next quarter. And so at the next update, I'm sure we'll have many more to deal with, and we'll do a much more focused COVID mandatory vaccination slot. So I want to now move into the misconduct dismissals. There are a few cases. The first one is Bakenrug Meat, and it's going to be presented by Lusanda Raphulu. Lusanda is currently head of our employment practice, but has been promoted to the head of dispute resolution. So I'd like you all please to join me in congratulating Lusanda on her appointment to head of dispute resolution. It's a fantastic achievement. Well done. Lou, over to you on Bakenrug.
Thanks, Graham. So my first case, Bakenrug Meat Pty Ltd versus Commission for Conciliation, Mediation and Arbitration. And this case was handed down in January of this year. This matter deals with the duty of good faith that's owed by employees to their employers. In this case, the employee, Ms. Carissa Hugh Oosthuizen, was employed by Bakenrug Meat. She was employed in the position of a sales representative, and she'd been employed by them since October 2013. It turned out that she conducted her own business that also involved meat products, in this case, biltong. She was dismissed in October 2016, and she was dismissed on a charge of dishonesty because she failed to inform her employer that she operated a business of her own that marketed these dried meat products. and also that she failed to then give the full and proper attention to the business of the employer. There were two charges at the disciplinary hearing. The first one being that she took on employment whilst also working in another capacity. And the second charge was that she was supposed to be calling in weekly or in a regular basis, and she had not done so. After being dismissed, she took the matter to the CCMA, and the CCMA held that her dismissal was substantively fair. It held that in this instance, the applicant operated a formal business with at least one full-time employee on rented premises and marketed these dried meat products. It held that at the very least, her employer should have been aware of this side business of hers, and that then the employer could have then determined whether or not there was a conflict between her side business and the business of the employer, and that she failed not to tell her employer, and that it was dishonest of her to do so. She was not happy with this outcome, and the decision was then taken on review to the Labour Court. The Labour Court held that at looking at the facts, she ran her business on the weekends, and that in fact, although she was employed by her employer, she was not employed by her employer 24 hours a day. So the Labour Court accepted that she ran her business on the weekends, and that even though she may have done some other things in relation to her business, she was not owned by her employer 24 hours a day. The judge found, therefore, that the commissioner had arrived at a conclusion that no reasonable decision maker should have reached, and therefore the charge that she took on employment whilst also working on another capacity could not be sustained. This matter was then taken on appeal to the Labour Appeal Court. The Labour Appeal Court looked at the approach taken by the protocol, the Labour Court, and said it appeared to amount to the principle that unless an employee informed the employer that she was moonlighting, and that it was to the extent that there was some level of competition between what she was doing and the employer's business, there was no actual offense, and that there was no duty to inform the employer that she had this business, and that there was no duty to inform the employer that there was a potential conflict of interest. The Labour Appeal Court said that much attention was given by the Labour Court to the fact that the employee contended that she ran this business on the weekends, and that she contended that it didn't negatively impact on the work that she did for the employer. The Labour Appeal Court disagreed with the approach that was taken by the Labour Court. The Labour Appeal Court said that the evidence clearly indicated that the employee failed to disclose an essential and important aspect that she ran this side business, that in fact it also involved meat products. And even though they may not have been identical meat products, she should have disclosed this to the employer. The Labour Appeal Court said that this side business involved meat products, and these were material activities that the employee should have disclosed to her employer, and therefore that not disclosing was acting in violation of the duty of good faith that she owed to her employer. It said that not informing her employer did amount to dishonesty. It said, therefore, that the decision of the CCMA commissioner was reasonable. The Labour Appeal Court set aside the decision of the Labour Court. It dismissed the review application, and it held that the dismissal of the employee was substantively fair. This is a good outcome for employers, emphasizing the duty of good faith that is owed by employees to their employers. On a practical level, we always advise our clients to have provisions in the employment contract stating that the employee can't be involved in any other business other than the business of the employer, or alternatively to require employees to disclose any other businesses, giving the employer an opportunity to be able to assess whether there's a conflict of interest between this business and the business of the employer, and also on a practical basis, knowing that the employee is involved in this other business, and therefore being able to assess on a performance basis whether the employee is putting their full attention to the business of the employer and not their side business.
Sorry. Thank you, Lily. Let's then move on to the next case, which is also yours as well.
So my second case is Ekurhuleni Metropolitan Municipality versus South African Local Government Bargaining Council and others. Also a January 2022 case. An important and interesting part of this judgment is that it involved an incident of sexual harassment, but not between two people who work together. The sexual harassment allegation is in relation to an employee of the Ekurhuleni Metropolitan Municipality and a member of the public who was at the offices of the municipality. Some important principles before I go into the facts of the matter, given the dynamics of this particular matter. Important principles given by the Labour Appeal Court on sexual harassment. The court said that sexual harassment is at its core concerned with the exercise of power and reflects the power relations that exist both in society in general and specifically within a particular workplace. It said that in the workplace, such harassment creates an offensive and very often intimidating work environment that undermines the dignity, privacy, and integrity of the victim and creates a barrier to substantive workplace equality. Importantly, where such harassment occurs at the hands of public officials who are enjoined to treat members of the public with respect and dignity, it offends not only against the constitutionality entrenched right to dignity, privacy, and integrity, but against the basic values and principles that govern the public administration. The result is that public services are accessed by members of the public in an environment that is hostile, intimidating, and offensive. The court said that both the 1998 Code of Good Practice on the Handling of Sexual Harassment, the other legislation in relation to this, including also the amended Code on the Handling of Sexual Harassment Cases of 1998, provide that victims of sexual harassment may include not only employees, but also clients, suppliers, contractors, and others having dealings with the business. It follows, therefore, that the 1998 and amended code apply to members of the public who access public services. Okay, so going into the facts of this case. So the member of the public in this instance was employed as a retentions clerk at Standard Bank. She attended the Ekurhuleni Municipality offices in Edenvale for the purposes of her driver's license. And she attended on 2 occasions. The first occasion was on 23 June 2015, when she went there to book her learner's license test. And she then returned on the 31st of August 2015 for the purposes of taking the test. The 2 complaints as follows. That on the 23rd of June 2015, when she went to book the test, when she was there and the cashier who took the money said to her that he was taking her number and her details, and she told him not to call. She testified that he then made sexual remarks that she looks like she tastes nice in bed, and she decided to ignore this event. She said even though he took her number, he didn't call her. She said that when she returned on the 31st of August 2015 to then take the test, the official who was there to sign her certificate and take the fingerprints was the same official that had sexually harassed her when she had gone there on the 23rd of June. And in her statement in regarding to the taking of the fingerprints, she gave this statement. He made sexual remarks again, saying I look like I am nice in bed. He also looked at my address and said he will keep it in mind and come to my place. When I had to put my fingerprint on the learner's certificate, he rubbed my hand in a very uncomfortable way. I took my certificate and went to reception to ask where I can go and lay a grievance, and the lady at the door pushed me aside and told me to let it go. I immediately went to the supervisor office. The supervisor called him and he denied all the allegations. I then advised the supervisor that since he doesn't even apologize, I would lay a formal complaint. This is when he said he will apologize, and I advised him that the apology was late and I would take matters further. At the internal disciplinary hearing that ensued after these events, he was found to have committed 2 acts of sexual harassment. Although he denied the allegations, the chairperson said he found it difficult to disregard the various testimonies given by the appellant's 3 witnesses. It was found that he failed to maintain a professional relationship with her and was found guilty of sexual harassment and dismissed. He was aggrieved with the dismissal and he referred an unfair dismissal dispute to the South African Local Government Bargaining Council. Her evidence remained substantively the same at the Bargaining Council, and his evidence at the Bargaining Council was that he can't apologize for something that he's never done. However, after having analyzed the evidence, it was found probable that he had committed the misconduct that he was accused of. However, looking at sanction and looking at the fact that he'd been employed by the municipality for 10 years and that he had a clean disciplinary record, the sanction was changed from a dismissal to a final written warning. Because of being dissatisfied with this reinstatement now and final written warning, the matter was taken on review to the Labour Court. At the same time, the employee referred a cross review, wanting the award to be set aside and wanting it to be found that it was substantively unfair and that the final written warning be set aside and held that he hadn't sexually harassed her at all. The Labour Court said that there were discrepancies in her evidence and that it was startling that she had not said anything at the time of the 23 June incident, and that only after the 23 August had she said something. It was found that some of her evidence should have been rejected. The court found, though, that the finding by the arbitrator constituted an irregularity, and the cross review was then upheld. Therefore, it was found that he hadn't sexually harassed her and that his dismissal was unfair. And the matter then went to the Labour Appeal Court. The Labour Appeal Court said that the Labour Court had taken a wrong approach here, and that the Labour Court's approach that it didn't make sense and that the evidence was not enough, said that the Labour Appeal Court said that even though there were some discrepancies in the evidence, there weren't enough discrepancies in the evidence for the rejection of the totality of her evidence. The Labour Appeal Court also gave reference to the case of McGregor versus Public Health and Social Development, and said it was made clear that we hold in our hands a constitution that equips in relation to the matters of sexual harassment when people's rights have been violated. And the Labour Appeal Court said that the Labour Court failed to take heed of this sentiment. It held that the approach in the review application was taken by the Labour Court in a manner of an appeal, rejecting the complainant's version on the basis that it didn't make sense, and that this was a wrong approach that was taken by the Labour Court. On the issue of sanction and that reversal of the dismissal with a final written warning because of the 10 years service and the clean record, the Labour Appeal Court said that in terms of the Sidumo test, the job was not to replace the sanction, but to look at fairness. It said, as to the issue of sanction, the appellant dismissed the third respondent for failing to maintain a professional client relationship on the basis that he had been found to have committed 2 separate incidents of sexual harassment. In finding that the sanction of dismissal to have been too harsh and dismissal unfair, the arbitrator recognized the serious nature of the misconduct committed, but relied on the third respondent's length of service and clean disciplinary record to substitute the sanction of dismissal with the final written warning. It said it was made clear in Sidumo that in terms of the LRA, a commissioner has to determine whether a dismissal is fair or not. A commissioner is not given power to consider afresh whether he or she would decide a different sanction. In arriving at a decision, a commissioner is not required to defer to the decision of the employer. What is required is that he or she must consider all relevant circumstances. The court held that the arbitrator was not given the power to consider the issue of sanction afresh, but was required to determine whether the sanction imposed was fair. It then held that the initial sanction of dismissal was to be upheld. So the overall outcome of this case was that he was found to have sexually harassed her. The dismissal was found to be fair, and the sanction of dismissal was upheld, and the reversal of that, because of looking at years of service and a clean record, was reversed.
Thanks, Lou. Sorry, so an important case then on this issue of sanction and a review of sanction. I think it's quite a significant case on that. There are just a couple of questions on the Buckenruch case that have come up. The one is, what would be the outcome if she was engaged in an activity that was not in competition in any way with the employer? It didn't involve a meat product, say she was moonlighting at McDonald's. Would the result have been different?
I think the court did make mention of the fact that it was particularly important because it was in a relevant industry. But the fact that she was engaged in a different business in itself, the court said that she should have disclosed that. So I think she would have been required to disclose that she was involved in a different business. That there was emphasis, particularly because of the correlating industry, but the different business on its own, I think would have been required to be disclosed by the employee.
And obviously it would help if there were policies in place that said, well, your contract says if you're going to do any business, you need to get permission, or you need to disclose, or you need authorization. Clearly, if you've got those in place, they will be upheld.
Correct. A provision in the employment contracts would help the employer.
Perfect. Thank you very much. All right, we're going to move on to the next case, which is the Molontoa versus CCMA, and Ayanda Nkabinde is going to talk to us about it. Ayanda is a senior associate in the employment department, and he will take us through that case. He's also responsible for compiling the program, so we can thank him for finding all the cases that we're dealing with today.
Thank you very much, Graham, and good morning, everybody. So yes, the case, or the first case with which I'll be dealing is Molontwa versus Eskom and others. It's a review application that came before the Labour Court in Polokwane, and its importance will become self-evident once I delve into the facts, but broadly, it deals with the right of employers to substitute a sanction that is lesser than dismissal with a sanction of dismissal. But that will become a bit more eloquent as I go on. So the facts of the case, the employee started her employment in 2013 with the company, and in 2016 she was invited to attend a training session that occurred in Midrand. And in order to travel to the training session, she went with one of her colleagues, and the colleague asked her, please pay me 400 Rand for petrol, I assume snacks and the like, etc. And upon her return, the applicant then went onto the company's database or their software, and she claimed a travel reimbursement. And she claimed it in the amount of 713 kilometers traveled, which amounted to about 2,500 Rand approximately, that she was reclaiming. And of course, it's significant that the vehicle that was being used belonged to her colleague. So in actuality, she hadn't incurred any travel expenses aside maybe from the 400 Rand. But it was only a year later in 2017 that the company became aware of this conduct. They received an anonymous tip informing them that several employees had been abusing this reimbursement system. And in response to that, the company launched an investigation. And they also sent out a notice to all employees saying, if you come forward, we will grant you amnesty. And the applicant, in her wisdom, did not come forward. And eventually, the decision was taken by the company to charge the applicant for misconduct. And eventually, at the disciplinary hearing, she was found guilty. But the sanction that was recommended, or rather imposed, was 7 days without pay. So she was suspended for 7 days without any pay. And she subsequently served that 7-day suspension. However, 2 weeks later, she received a letter from one of her managers, in fact, the general manager at the plant that she worked. And she was invited to make representations as to why she should actually not be dismissed, given that she had been found guilty of the conduct. And through her trade union, she contested or disputed the entire process. She believed that the matter had already been dealt with and finalized. And eventually the company decided that she would be dismissed, and aggrieved by that decision to dismiss her, she referred an unfair dismissal dispute to the CCMA. At the CCMA, the commissioner found that the dismissal was actually substantively and procedurally fair. And so, aggrieved by that decision, the applicant then approached the Labour Court in an attempt to review and set aside the commissioner's award. Now, the actual judgment itself, I find to be a very useful judgment. It was written by Judge Moshwana, and in it, there's quite an extensive examination of the case law that deals with this particular issue, and quite a sophisticated level of engagement. And in coming to the decision that the dismissal was substantively unfair, the Labour Court considered a number of schools of thought that had emerged from several different cases. And broadly, maybe the ones that are necessary to highlight now. the court found in its exposition of the law that one of the schools of thought that had emerged was that the substitution of a lesser sanction is possible and permissible, but the employer must be able to show that it's fair. And on that construction, or in terms of that school of thought, the court found that that would fit quite nicely with the constructs of the LRA, because it would merely require an employer to go to the CCMA and explain why it had taken the steps that it had taken. But there was another school of thought that had emerged in the case law. And that said that, in essence, it is only permissible to replace a lesser sanction than dismissal. It's only permissible when the employer has provided for it in either their disciplinary code or in terms of some kind of collective agreement. And begrudgingly, the judge in this case decided that he would have to go with the second approach. And the reason for that was simply because the Constitutional Court, in a case of Kruger versus CCMA, had decided on this approach previously. So in essence, the court was bound by a precedent that was set in previous cases. And I say that it was begrudgingly because the judge pretty much said so himself in the judgment. He would have much preferred to go with the fairness route, which he believed fell squarely within LRA considerations and traditional employment law considerations. But because the Constitutional Court had previously decided on this issue, he felt that he was indeed bound to go that route. And so eventually, dealing with the actual reasonableness of the award, the judge found that the award was not reasonable because the commissioner ought to have examined the question of whether or not it was permissible for an employer to substitute the sanction. And I think what was also quite important in this case was the fact that the originally recommended sanction had actually been served. So that 7-day unpaid suspension had actually already been served by the employee in this case. So the court was then required to determine what would be the appropriate relief to grant the employee. And ultimately, the employee had claimed reinstatement, but the court found that reinstatement in this instance would not be appropriate, just given the level of the misconduct. And eventually, the court found that they would award the employee 10 months compensation. And I think this case is quite important because, well, it settles the legal debate, perhaps in a manner that Judge Moshwana would not have favored, but ultimately had to choose anyway. And so it's important for employers to just take cognizance that in the event that they wish to exercise some kind of power to overrule a recommended sanction, it's necessary to provide for that power within an employment policy or a disciplinary policy or in a collective agreement. And yeah, that would conclude the case.
Thank you. Right, panelists, we've got 15 minutes left. We've got 4 cases. I have a sense that we're only going to get through 3. So if I could ask you all, please, to try and be as crisp as possible in terms of them. Sorry to do this to you. Zawadi, you're up next with the Jacobs case.
No stress. Thanks so much, Graham. So I'm going to speak on the Jacobs case versus KwaZulu-Natal. Was also handed down in 2021. First, quick preliminary points. This is probably one of the most scandalous cases I've read. Ayanda, I'm worried about your well-being. Don't know where your mind has been. The facts of the case are this. So the employee, right, was on a selection panel. And in terms of her appointment, she, together with other panelists, were interviewing candidates, and they would recommend for their appointment. Now, the employee and the employer entered into a confidentiality agreement, right, together with the other panelists. And in terms of that agreement, essentially, they were required to keep all the information, pertaining to the selection process confidential. Now, following the process, the panelists, including the employee, recommended candidate A for appointment. However, subsequent to that meeting and that process, it became clear that the minutes of the meeting had actually indicated that the employee and the panelists had recommended candidate B for appointment. And it was actually candidate B that was eventually appointed. The employee went to her seniors, the head of the department, and also her line manager, basically explaining that there'd been a mistake and that the minutes had been amended and essentially that the minutes were incorrect. She was informed by her seniors that she should just basically keep this matter quiet and keep it a secret, and she should proceed and not talk about the fact that the minutes had been amended. Again, fearing for her job security, she just signed the minutes and said nothing and kept it a top secret. Now, sometime later, the employee was approached by a union official, and in a completely unrelated matter, the union official asked the employee to provide evidence by way of an affidavit, right, in legal proceedings, right? And essentially the employee's evidence related to her experience as a panelist in the selection process. Now, essentially in this affidavit, the employee disclosed that while she was a panelist, there had been an incident where the panelists had recommended a certain candidate for appointment, but the minutes of that meeting had reflected another candidate for appointment, and that candidate was in fact appointed. Now, the employer found out about this and said basically that she was prohibited from disclosing this information because the parties had entered into a confidentiality agreement. The employee was then dismissed on the basis that she had breached her obligations in regard to confidential information. And naturally the case before the Bargaining Council, the Labour Court, and the Labour Appeal Court is, can the employee be disclosed for disclosing information which is required in legal proceedings? Now, the Bargaining Council and the Labour Court basically said, look, the answer to this question is basically rooted in whether the employee was truthful in her evidence. The Bargaining Council said that she was actually dishonest and the minutes were actually not amended. She took this on review and the Labour Court came to the same finding. The Labour Appeal Court, however, said that this was incorrect. The Labour Appeal Court said that notwithstanding that the employee failed to file a complete record and wasn't essentially clear the evidence she led at the arbitration proceedings, the employer had conceded that the minutes were amended, and the concession was made during, during evidence at the appeal court. And essentially, the court found that the employee had been truthful. Notwithstanding this, the employer still asserted the confidential agreement and said, look, doesn't matter if she was truthful or not, she disclosed confidential information. And the crux of the matter is that the court said this. It said that an employer cannot rely on a confidential agreement when it is trying to conceal wrongdoings that it has done in the workplace, particularly what that information is required in legal proceedings. In these circumstances, permission was not required from the employer. Now, the takeaways from this case are this. First off, employers don't commit any wrongdoings. Second takeaway, most importantly though, is that even if a confidential agreement has been signed with this confidential information, an employee may disclose that information if it is required in legal proceedings, particularly if it is in the view or with the view of unearthing wrongdoings which have been committed in the workplace, as this current case demonstrates. And that is basically the conclusion of the case.
I think an important case as well. Thank you, Zawadi. Melissa, over to you on SA Metal Group. Again, you've got a few minutes, like 5, and then we're over to Nikita.
Thanks, Graham. Pressure's on to be super quick. So this is an interesting case. It's a Labour Court decision and it was a review of an arbitration award, but it piques our interest because it deals with polygraph tests. And in this case, the employer heavily relied on the evidence of polygraph tests in a decision to dismiss an employee for intended theft. So in this case, a large bundle of copper wires was discovered in a locker of a security officer change house. And an employee was charged with intended theft on the basis of the outcome of a polygraph test, which indicated that he was not honest when he answered questions concerning his involvement and knowledge of the theft of the copper wire from the employer. And that is the only evidence that the employer relied on in the disciplinary proceedings. At the arbitration proceedings, the employer did call a witness who was a Mr. Jobe, and he provided a statement of evidence where he had said that he had seen this employee prior to the discovery of the locker on at least 4 occasions where he sat next to the locker. He recalled, he remembered seeing him there at least 10 times, but specifically 4 times, but couldn't remember the exact dates. And it was common cause that this employee was not the locker of the particular employee. And he also said that he had spoken to 2 other guards who had also seen this particular employee near the locker or using the locker frequently, but those 2 other guards were not called to give evidence in the arbitration proceedings. At the CCMA, the arbitrator found that the employer had failed to establish that the employee was guilty of misconduct in this case and had awarded reinstatement. And the basis of the reasoning was because the witness that the employer called at the arbitration proceedings hadn't testified at the disciplinary inquiry. And so the employer found the employee guilty solely on the basis of the polygraph test. The matter was then taken on review. There were a number of grounds of review which were raised by the employer in this case. And indeed, the arbitrator had actually misdirected himself in some respects, and there were defects of the case. But the court focused on whether the outcome of the arbitration award was still one that a reasonable commissioner could make. And the court found that it was a reasonable decision because the court couldn't take into account the evidence of the 2 other inspectors. It was hearsay. They were not called as witnesses. Mr. Jobe's evidence was unreliable. He couldn't exactly recall the number of times he saw the employee by the locker. He couldn't remember the dates, and it was inexplicable as to why he didn't give evidence in the disciplinary inquiry. So the court agreed with the arbitrator that the polygraph test was the sole reason the employer dismissed the employee. And it held that polygraph tests are not accepted as evidence in the absence of expert evidence being adduced as to its conceptual cogency and accuracy and its application in a particular case. So you need to call the polygraphist to give evidence as to his expertise in the admission of the test and why the polygraphist came to the conclusions that it did in the assessment of the test and the questions that were asked. And there was no such evidence of this in this case. And indeed, in this case, all the other evidence relied on by the employer was unreliable. So it would be unreasonable to find that the employee had actually committed misconduct in this case. So this case is a great reminder that whilst polygraph testing is frequently used in the context of workplace discipline, and it's of great assistance in investigation processes, it's by no means uncontroversial. And courts have consistently approached polygraph tests with caution. Polygraph tests alone generally is used to corroborate other relevant and valid evidence that's presented. It can be relied by itself, and you must have expert evidence which accompanies that. Thanks, Graham. I hope that was 5 minutes.
It was well done. Thank you. What I'm going to do, Ayanda, forgive me, but I'm going to push your case out onto the next program because it's more substantive. And I'm going to close off with Nikita.
Thanks, Graham. I'm going to try and be very quick and speed through this judgment as well. So the last case that we're discussing is Woolworths versus CCMA. And essentially, this is about whether an employee can be dismissed for attending a rugby match. And the answer is if the employee tells the employer that they've taken sick leave and then proceeds to attend the rugby match, then yes, you can be dismissed for that. So very briefly, in terms of the facts, the employee here informed one of the managers on a particular morning that he was ill and wouldn't be going to work that day. But then he proceeded to travel with his father and actually attend a rugby match on the same day. And the next day, when the employee returned to work, his manager asked him where he'd been, and he actually admitted that he had attended a rugby match. So the employer then investigated it, and the employee was charged with gross misconduct for abusing the company policy and sick leave, and he was ultimately found guilty and dismissed. The employee referred an unfair dismissal dispute to the CCMA. And very surprisingly, the commissioner found that the dismissal was both substantively and procedurally unfair. And the commissioner's reasoning was that the employee actually didn't try to hide the fact that he went to the rugby match, and he hadn't actually been charged with dishonesty. So Woolworths was obviously not happy with this outcome and took the matter on review to the Labour Court. But again, very surprisingly, the Labour Court actually agreed with the CCMA that the dismissal was substantively unfair. And the Labour Court found no basis to interfere with the Commissioner's finding that the employee was not dishonest. And interestingly, that there was no evidence of a policy that requires an employee to report for duty if they feel better after taking sick leave. So the matter then went to the LAC, and the LAC luckily took a very dim view of the CCMA and the Labour Court's finding. And the LAC held that it's very clear in this case that the employee acted dishonestly when he took sick leave and then proceeded to attend the match, knowing that he would be paid for that day. And the LAC rejected the argument that the employee's conduct didn't cause a breakdown in the employment relationship, and held that a lenient approach to dishonesty can't be tolerated. This employee was employed in a senior position. He was palpably dishonest, which negatively impacts the employment relationship and the relationship of trust. And the court, didn't apply a formalistic approach and held that it didn't matter that the employee was charged with breaching a company policy because it was patently clear that he acted dishonestly. So in this case, it didn't matter what the technical wording was on the charge sheet. And importantly, this judgment, it's relevant because it's actually in line with a long line of LAC judgments where the courts put a premium on honesty and the relationship of trust, and where employees act dishonestly, it's not an expression of moral outrage to dismiss the employee, but it's actually an operational response to the risk that it causes to the business. So the LAC is really applying a long line of cases where dishonesty is not tolerated in the workplace. I tried to rush through that, Graham.
You did fantastically. Well done. I'm aware there are quite a few COVID-related questions. So what I intend to do is we will focus more on COVID at the next update. There will be, as I say, more issues arising. Obviously, if you've got any specific questions, you can obviously call one of the panelists afterwards. I'd like to thank the panelists. You were exceptional. Thank you very, very much for your time and your effort. You all did us proud. Thank you very much. And thank you for joining us, all of the audience, and look forward to seeing you for the next update. Thank you very much.